legal advisor who was unfamiliar with the bills and works in different work streams to consider objectively the legal argument presented by Advocate Van der Merwe to the committee. It is therefore a unanimous view that the legal advice offered to the committees is sound. There are no alternative legal views to the advice provided by Advocate Van der Merwe. Furthermore, it is not practicable or efficient to have multiple legal advisors on a project, as this can create inconsistency and inefficiency. Advocate Van der Merwe remains the most appropriate person with a relevant background, skills, and knowledge to best serve the committee. Her thorough engagement and therefore understanding of the issues related to these bills over the past period of 6.5 years are beyond any doubt. CLSO is committed to providing Parliament with advice that is in accordance with the basic values and principles governing public administration provided for in Section 195. Specifically, that advice must be impartial, without bias, and development-oriented. To achieve this outcome, legal advice is discussed with peers and seniors, and deliverables are subject to quality control exercise. Advocate Z. Adhikari, Chief Legal Advisor. So that is the memo that we received, honorable members. Can I check if this is accepted by the committee? Honorable Lund, followed by Honorable Moimang.
Thank you, Chair. Thank you for that. Just two things. Firstly, I do think it is not unreasonable. We are all on a WhatsApp group together. It would have not taken much to send that to us so that we can actually read it as well, because now I'm speaking to it without having received it. And I do think it's just fair making sure that these things are circulated to all committee members so that we can then look at it carefully. From what you have read, and not now obviously not having received it, I just want to raise four things. The first thing is the appreciation for the time they took in getting back to the query, so that we can just note that. The second thing is, I want to put it clearly, and I did say it the other day, at no stage was there ever any aspersions cast on the competence and abilities of Advocate Van der Merwe. So and again, I don't have it in front of me, by responding in kind, I mean, that was something I think that Honorable Dangor or Moimang said. Nowhere was that said by myself. My question was that we have another set of eyes looking at it. And that was done from, I think you read someone from a different work stream. And that is exactly my point that I made the other day, that you need to have another set of eyes having a look at it, because if somebody works on a piece of legislation for such an extensive period of time, there's advantages to that, but there's also disadvantages and biases that may creep in. And that's exactly what I raised, that somebody else may have a look at it as well. So I do think that as well. The workflow on that, I'm not going to interpret it now. You see, Chair, this is the problem. I now try to remember from what you have read. The one thing I do not necessarily agree with, but it doesn't have to be a debate, but I'm just putting it to you, is it would in fact be good to have different opinions that even from this department for the committee to consider. We are all capable of looking at or I would believe we are all capable looking at the different opinions and apply our mind on what would work best for us in the legislation. But overall, I just wanted to thank the time you took in getting back to us, and I would appreciate if you can circulate that to us as soon as possible so that we can actually read through it and go through it. Thank you.
Thank you very much, Honorable Lund. I've already circulated it on the WhatsApp group. Honorable Moimang.
Thank you, Chair. Let me also appreciate the effort taken by the legal advice of Parliament in terms of responding to the request that was made emanating from the query that was raised, and given the extensive nature in which the advice covers, I guess the Chair this ultimately put the matter to rest because of the extensive nature in which the advice speaks to, amongst them the review of the work that was done, the consistency in terms of what the two committees received from the legal office, but more than that, the appreciation of the confidence that the CLSO plays on the work that the team is doing. So therefore, Chair, again, this lays the matter to rest. Thank you.
Thank you so much. Honorable Tango. Honorable Tango, you can continue.
Apologies, Chair. I was having a bit of difficulty logging in earlier this morning and seem to have some problems logging in sometimes now. However, having said that, Chairperson, we note what Honourable Lont is saying, but I think we also need to note that the person who was there representing the Legal Services Department indicated that the Secretary of the Legal Service Department, or the manager thereof, would also be looking at this. And that's the second pair of eyes that did look at it, and it was indicated in the last meeting that this would in fact happen. So I think we need to appreciate that appreciate the fact that Advocate van der Merwe has done the work, and also appreciate the fact that a second set of eyes had looked at the work and approved it. Thank you very much, Chairperson.
Thank you very much, Honorable Tango. I will now allow Advocate Samara Ali to indicate and explain the procedure that will be following. But before that, I would like to welcome back Honorable Eric Landsman, and like to formally express our deepest condolences when he lost his wife. We welcome him back to the meeting. I would also like to thank Honorable Dodovu for always being available to stand in as an alternate on behalf of Honorable Landsman. Thank you very much, Honorable Landsman, for your attendance to this meeting. We welcome you back. Can I now hand over to Advocate Samara Ali to take us through the procedure that will be following?
Good morning, Honorable Chairperson. Good morning, honorable members and colleagues. Chair, this process that we will follow is this morning. You can perhaps, on the agreement of the committee, take us through clause by clause in terms of the amendments that were proposed. We can then allow the department as well as Advocate Charmaine van der Merwe to respond if there's any required responses, if members require any responses from there. And then we can go on to voting per clause. Strictly speaking, when it comes to the voting, it's 5 provinces in favor to carry the proposed amendment, and each province, Chair, I need to stress that each province only has 1 vote. in an instance where there's two members from one province, it's the member from the ruling party or the member from the majority party within that province that would carry the vote. The other member, we can note down their opinion in terms of a minority view, but that member cannot vote. Thank you, Chairperson.
Thank you very much, Advocate Ali. Honorable Lont, I see your hand is up again. Can you allow our members if they have question on the explanation given by Advocate Shamara? Honorable Lont, go first.
Yeah. Thank you, Chair. I just want clarity on that last point made. I know it was raised a while back, and then you asked for, I think you asked for the opinion on this to come back. Now, the whole way the NCOP is set up is to, I'll quickly, I mean, you know, there's 10 delegates allocated, 6 permanent delegates, but there's a proactive and intentional way in making sure that there is diversity in the representation from the different legislators. So I don't have to go into those now, but then coming to a committee and actually suppressing those different voices is a bit concerning. That we just say that vote goes to the majority party. And I do want to request formally in writing that we get an opinion on that. Unless there is one and I've not seen it, and I do apologize for that, and then it can please be sent to me. But it kind of seemed counterproductive to what the intention was when it was written, how the representation from the different legislators, the 10 delegates and then the 6 permanent delegates are determined, and then also on the committee. So if we could get that, Chair, I would really appreciate that. And if I missed it, I really apologize for that. If you can then just send that to me.
Okay. Would like to respond to that, Advocate Samara?
Honorable Lon, thank you for your query. I will provide a formal procedural opinion to you before the next meeting. In fact, I will provide the committee with the formal opinion. With regards to the voting, it is set out in the Constitution, and it's 1 vote per province, and a majority of 5 will carry the opinion. In terms of representing the various opinions, indeed, that will be included in our report, but it will be recorded as a minority view. It will not be recorded as a vote, because only the permanent delegates or the permanent members to the committee may vote. And in the absence of those members, an alternate can vote. The problem arises here is, I think, where there's 2 members from one province, and one is a member of the opposition party and one is a member of the ruling party. That goes straight to the Constitution, and in terms of Schedule 3, Part B, where it states very clearly that in terms of the numbers of delegates in each provincial delegation, it's determined by the proportional representation of that party within that province. But honorable members, please allow me the time. I will provide a formal opinion to you before the next meeting. Thank you.
Thank you so much. Honorable Matebula, followed by Honorable Long.
Thank you very much, Chair. I would like to ask if the member, for example, the member of the majority party is not there, it's only me in the committee. So will you able to note my vote now? That's what I wanted to ask.
Okay. Honorable Lont, and followed by Honorable Maimang, and then we go back to Advocate Samara.
Yeah, Chair, thank you. It kind of latches onto what Honorable Matebula has said, but I have no problem with proceeding as is. And then we'll get the legal opinion from Shamara. But I would have hoped that we would have gotten that before the voting. But then again, it's just the fourth order, the order in which we do it. I would have hoped that we got that opinion first, because if I read it and I'm correct now, we'll basically just have one governing party vote on this committee if you just bring in other people. So that's a way of suppressing the vote of the opposition, and I am concerned about that. But we'll wait for the opinion. But it is a concerning thing that the opposition voices. I mean, you can note minority opinion, but the actual vote is being taken away, and that is the concern. But we'll wait for that legal opinion, look at that, and then take it from there.
I think it only applies to Section 76, Honorable Lont, but when it comes to Section 75 and 77, I think individuals do vote, like in the House. You remember when we deal with the reports that are within the Section 76, it's provinces. Even in terms of the declaration will be made by provinces, not political parties. Parties also would come when it's Section 77 or Section 75 with the declaration. That has been a practice. But let's allow Honorable Moimang, and then we go back to Shamara to respond, and we'll come back if there are other heads.
Thank you, Chair. Appreciating the commitment made by Advocate Shamara that legal advice will be provided in writing. One moves from the point that proportional representation is a fundamental principle that was meant to accommodate divergent views, but at the same time appreciating the fact that numbers that you garner at the poll carries weight, and but that does not tantamount to majoritarianism. Hence, the formula of proportional representation is quite important. And my view is that let's appreciate the reference that was made in terms of a constitution that covers that, but at the same time allow the next in the next session, like as Advocate Shamara has indicated, that the legal advice in writing will be provided. Thank you.
Thank you very much. Honorable Tango.
Chairperson, we received negotiating and voting mandates from the province in writing. In this instance, we have received from the Gauteng province a negotiating mandate and a voting mandate in writing. Of course, the final voting will be after we've concluded all the business here, sent it back to the province. But for this, we have a indication in writing from the province as to which direction we should go. Now, if there are going to be two different negotiating mandates from the province, I'm not too sure what that's going to mean.
Yeah. I don't know if it's all hand, Honorable Mateo. I see your hand is up.
It's an old hand.
Okay, let's go back to Advocate Shamara. Ali.
Thank you, Chairperson. Going back to Honorable Matabula's question, indeed, the permanent member to that committee has a right to vote, be it the opposition member or the member of the ruling party. However, like Honorable Dango has indicated, members can only vote in terms of the mandate in front of them, especially where it comes to a proposal or proposed amendment that's contained within that mandate. With regards to Honorable Matabula's specific question is, if the permanent member is not in that committee and she's standing in and she has to vote, the member has to vote in terms of the mandate in front of her. Like I've said before, her opposition views can be noted, but the member has to vote in terms of what is contained in the mandate. Thank you, Chairperson.
Yeah. Thank you so much. I think this has now been clarified. Can you just repeat again, because I think this area now kind of like Claudette, your explanation on the procedure that will be following with regard to the mandates and the position of the CLSO and the DTIC. If just could clarify that before we start again.
Maybe we can read out clause by clause in terms of the amendments. If there's any requirements or if there's any need for Advocate van der Merwe or DTIC to respond, they can. And then we go to the voting clause by clause. And like I said, 5 votes will carry the amendment. Thank you.
Thank you so much. Ms. Solomon, can you please flight the clause by clause?
Can I just correct a question of terminology there? 5 provinces will carry it, not 5 persons.
Yes. Okay. Oh, so we're dealing with the copyright amendment bill as amended by the Portfolio Committee on Trade and Industry. Is it the document that we'll be using? Shamara?
That's correct, Chair.
Okay. And can we then continue there? We deal with the general explanatory note. It indicates that where there are brackets, it means in bold type, it indicates omission from the existing enactments. And the word underline with a solid line indicating insertion in existing enactments. Can we go down? Is that the next page? Doesn't have the heading. Okay, on page 3, thought that it was going to.
Sorry, Chair, Enrico, if you can please, Enrico, if you can please scroll up and if you can also just close that window on the side and then also just minimize a bit, just so that more of the text can fit onto the screen.
Enrico, you see this thing that says convert, you move up, there's an arrow there, click on it. You see convert, that says document language, English, there's an arrow next to that, click on it. No, down. You see convert, and then you see document language.
Clarity, Chair.
Yeah.
Just one clarity. Are we starting with the proposed amendment from the DTIC and CLSO, or what? Or we're going clause by clause? Just clarity on that aspect.
What we're going to be doing, we read out the clause by clause, and then we go to what the provinces are saying, and also what the DTIC and CLSO are saying. And then we then vote.
Thank you, Chair.
All right, thanks. Seems like Enrico doesn't see what I was asking him to do. I don't know if it's visible. Can you make it 100% instead of 75, Enrico? Okay, that's better. Is that the definition?
No, sorry, Chair, Enrico, please scroll up as well, please, because you're on the 3rd page and we need to be on the 1st page.
Yeah.
Chair, a slight chuckle from my side, but this is not the first legislation we're dealing with. And there was the specific reason why we asked that we do this in person for this part. And I do appreciate that venues are difficult to achieve, but this is important. There's all range of other factors coming at play that might affect members of the committee. So when we make a constructive input, it's not to be funny, it's because we know it works best. And I do hope that when we do with this legislation, that as important as this going forward, we make that effort to book in advance the venues for us. I'm sure also the House chairs will support us when we motivate.
Yeah, as we indicated, it's not a question of motivation, it's a question of availability of venues, Honorable Lont. We dealt already with the 2 bills that we passed using this platform. So I don't think it's a real challenge. Other committees are also doing the same. Can we scroll down then to page 2? The purpose. So the bill is to amend the Copyright Act 1978 so as to define certain words and expressions to allow for further limitations and exceptions regarding the reproduction of copyright works, to provide for the sharing of royalties in copyright works, to provide for the payment of royalties in respect of literary, musical, and artistic and audiovisual works, to provide for resale, royalty rights, to provide for recordal and reporting of certain acts, to provide for the accreditation of collecting societies, to provide for mechanism for settlement of dispute, to provide for access to copyright works by persons with disabilities, to provide for the licensing of orphan works, to strengthen the powers and function of the Copyright Tribunal, to provide for prohibited conduct in respect of technological protection measures, to provide for prohibited conduct in respect of copyright management information, to provide for protection of digital rights, to provide for certain new offenses, and to provide for matters connected herewith. So in terms of clause 1, section 1.
Chairperson,
yeah.
If we are going to give you this very onerous task of reading out the entire bill word by word, it's going to take 5 meetings of this nature. I would suggest that we've received this in writing. We can either agree to it or not agree to it, and put our positions forward. But to expect you to read out every word is going to become onerous for you. I hope you've got enough water for that.
Okay, let's try and continue the same way. In clause 1, we by insertion of before the definition of adaptation of the following definition, accessible format copy means a copy of work in alternative manner or form, which gives a person with disability access to the work, including to permit the person to have access as feasible and comfortable as a person without disability. B, by the insertion after the definition of artistic work of the following definition, art market includes an auctioneer or auction house, the owner or operator of art gallery, the owner of operator of museum, an art dealer, or E, a person otherwise involved in business of dealing in artwork. Audiovisual work means the embodiment, moving images. Okay, let's go back again, Enrico? Then what it means is that we will have to then check what the provinces are saying then with regard to clause 1, section 1. I thought that because there was a document that was circulated, I thought we were going to use that document because it was going to make it easier, because we would see what the provinces are saying, and also what the CLSO and the DTIC are saying, and then we take a vote on that. Because now it will mean that we must put this bill on the screen and then take it out and then put the other one of the province's mandate as well as the responses. So we rather do that, Samara?
That will be in order, Chair.
Yes. Okay, thanks. Thank you so much. Going to make a life easier that way. Okay. There it is, honorable members, in terms of clause 1 on the definition, the accessible format. Just don't move. Okay, can you just move down a bit? Just want to see, other than Gauteng, if there's any other province on this issue of accessible format. Just go down. Yeah. Okay, move up again there. Okay. It is, honorable members, in terms of the recommendation, in terms of the negotiating mandate from Gauteng on the accessible format copy, it recommends that to retain the court decision of the accessible format copy for coherence with Plan SA CC and conformity with the Marrakesh VIP treaty, and also the TTIC and the CLSO responses recommended retaining the bill's wording, that is, the accessible format copy in bill is broader and provides for more works, and then the definition on CLSO, the definition read with section 19D, exactly as the court is read and was read in, save for a broader application, as the treaty and the court were limited to visual impairment. Our bill has to go broader due to our constitution requiring equal treatment. This is not prohibited by the treaty. It is not required or recommended to use the exact word of the treaty. Why pour on exception and limitation and exceptions to copyright and related rights vary from country to country due to particular social, economic, and historical conditions. International treaties acknowledge this diversity by providing general conditions for the application of the limitation and the exception, leaving national legislatures to decide if a particular limitation or exception is to be applied, and if it is a case, to determine its exact scope. Accessible format copy means a copy of work in an alternative manner or form, which gives a beneficiary a person access to work, including to permit the person to have access as feasibly and comfortable as a person without a visual impairment. Can I just check for clarity purpose, Advocate Fademeve and Dr. Masocha, what is the exact clause or on this one? I see the broader explanation. How is it different from what Gauteng is suggesting? Advocate?
Good morning, Chair, and good morning, members. What happens here is that the proposal from Gauteng is that the definition in the bill must be amended to read as per the court's read-in. However, what we recommend is that we don't just do what the court read in, because the court's read-in was focused on persons with visual impairment. And our bill must go broader because of our constitution. So the definition in the bill does provide for what the court has indicated it must provide, but it also goes further and makes provision for other types of works and disability. Thank you, Chair.
Thank you so much. Want to add Dr. Masoch? DDG Masoch? Okay. I don't know if she's still logged in. Honorable members, that is an explanation. Now we will be voting on that clause 1 on the accessible format copy. We will do that by a show of hand. Those who vote in favor of the acceptance of the clause accessible format as explained by Advocate Fademeve, can you please raise your hands? Ms. Madia, you'll help me to with the...
Okay, yeah, yes, Chair. Okay, thank you, Chair. Chair, in terms of the provinces that have voted in favor of accepting the response from the CLSO and DTIC, we have we've got the Northern Cape, we've got Limpopo, we've got Gauteng, we've got Eastern Cape.
Also support. I have a problem of voting.
Okay. Noted, Honorable Latsma.
Okay, okay. So we've got with the West as well, as indicated by Mr. Honourable Landsman. So just to go to that again, we've got Northern Cape, we've got Limpopo, we've got Gauteng, we've got Eastern Cape, and we've got Free State.
Free State. Okay. How many altogether?
6 in total, Chair.
6 in total. Okay. Can we allow ask members to lower their hands? Okay. Can we now move to those who are voting against the acceptance of this amendment? Yes, this amendment. Can you help me again?
I don't see any indication on the platform, Chair.
Okay. Can we check those who voting or who are abstaining?
Chair, I've got Mr. Lund representing the Western Cape. And then we've got, as indicated by a colleague, Advocate Ali, we've got Honourable Brodsef representing a minority view from KZN, and then Honourable Matavula representing a minority view from Limpopo.
Okay. Thank you
Sorry,
so much.
Chair, let me just want to get a point of clarity. I apologize for just jumping in.
Okay.
I just want to check now. So what was, I understand that Honourable Matavula is the second person from Limpopo. So that now gets noted as a minority view. Did I miss a previous vote from KZN, Chair, so that she frames Honorable Browter as a minority view? Because if there wasn't a previous vote from KZN, there is no reason to frame Honorable Browter's vote as a minority view.
Okay, can you clarify that, Advocate Samara?
Thank you, Chairperson. Honorable Lont is in fact correct.
Okay.
We will have to note Honorable Brotterset's vote as, I think it's abstention. Thank you.
All right. Thank you so much for the clarity. Okay, so the vote is carried then, honorable members, with the abstentions that are recorded. Can we move down, Mr. Bazia? Can you move up? No, sorry, down, because, okay. Also a bit confused now. So this whole one until is still that issue of accessible format, and then can you move up again? Problem is that the document is also on the same device I'm using. Okay, go down, because yeah, it's the same. Go down until you get to the NDT. Okay, you authorize NDT. Okay, can you just move down so that we see which other provinces? Okay. All right, just move up again. All right. In terms of the authorized NDT, KwaZulu-Natal, Gauteng, and Northwest, let me read them, each one of them. In relation to the definition authorized NDT, some of the stakeholders advise that the finding of the Constitutional Court in relation to 19D of the Copyright Act in Blind SA versus the Minister of Trade, Industry and Competition and others should be considered. That's what KwaZulu-Natal is saying. Gauteng says adopt the court-crafted definition of permitted entity by simply introducing an aligned word at the start of the Copyright Amendment Bill, Section 1CB, to read as follows: B, an entity including a government institution or non-profit organization. Can you go down, Mr. Bazia? Northwest, definition for authorized or permitted person or entity who may make accessible format copies, and instead refers to any person as may be prescribed. No clarity has been provided as to how such a person will be prescribed, not by whom, but is assumed to give effect to the provision. Further regulation will be required in circumstances when a perfectly suitable definition exists in the Marrakesh Treaty and approved by the Constitutional Court. Can you move up? Then I want to read it up. Yes. I want to read the responses of the CLSO and DTIC. Amendment is proposed in terms of the blue font, be an entity including a government institution or non-profit organization that provides education, instructional training, adaptive reading, or information access to persons with a disability on a non-profit basis as one of its primary activities or institutional obligation. The Plan SA judgment is noted. The court-crafted permitted entities is not in line with Marrakesh Treaty. Authorized entities is more preferred. The CLSO, the definition of the bill is beyond the Marrakesh Treaty and in line with the Constitution. Countries are allowed to provide more rights and benefits to their citizens. The bill uses the term authorized entities proposed as per court's read. Note on the profit purposes is also a specific requirement in 19D. Coming back to you again, Advocate Van der Merwe.
Thank you, Chairperson. And just to confirm, Dr. Masocha was just kicked off the platform. She's back now. Just a response on this, Chair, we do actually recommend the proposed wording that is proposed by Gauteng. And although they're not recommending specific wording, the proposal from KZN as well. So that is what we're proposing in the read-in, that the words an entity and not-for-profit be added to the definition. And then just also to respond to the Northwest, the proposal there about the regulations, just to say that there's already regulations provided for this concern in the bill, and therefore no amendments are required. Thank you, Chair.
Thank you so much. Any addition, Dr. Masocha?
Morning, Chair. Morning, honorable members and the delegates from provinces. No additions. I agree with the comments that we have provided and also the explanation from the advocate. Thank you.
Thank you so much. Honorable members, can we then vote in acceptance of the bill? I mean, sorry, the clause. Yes, Honorable Protestant.
Chairperson, once again, just a point of clarity, and once again, sorry to just interrupt.
No problem.
So the negotiating mandates were given before the responses were received by the department and the CLSO. So that leaves us in a very difficult position where normally if a province raises an issue on their negotiating mandate, they would then receive the province, the input from the department and the input from the CLSO, and then perhaps come back with a revised position. But here today, I'm, as the KZN person, placed in a difficult position where I don't have the comment from my colleagues on the response from the department and the CLSO. So do I then have to blindly follow the mandate? If we could just get clarity on that, because obviously the colleagues in the province haven't had a chance to say, okay, we hear what department and CLSO are saying, but this is still our position, or thank you very much, you've clarified that, and we adapt our position. Or adopt our, adapt our position. So I don't know where that leaves me as a delegate. Thanks.
Okay, Advocate Chamara.
Thank you, Chairperson. With regards to the question posed by Honorable Brotteset, and specifically relating to the mandate that's provided by KZN, there isn't a specific position put on any of the mandates that are before the House. It was just recommendations that they had put forward. Does that answer your question, Honorable Brotteset?
Sorry, my apologies. My signal dropped there. Could you just repeat?
Okay. In terms of the mandates that we've received, many of them have actual proposed amendments contained in them. Now, with regards to KZN, we don't have a specific position on an amendment. We just have recommendations. So basically the voting is up to you, as there is no proposals in the mandates within which you should vote in terms of. With regards to, do you perhaps have an additional question to that, Honorable Brotteset?
No, I don't. It just, as I say, it leaves me in a difficult position, and it almost leaves me in a position where I need to abstain because I don't know what the response is from the province. So yeah.
Chair,
I think what is happening now with Honorable Botfred said is that we are on our own as a select committee. We are discussing and expressing views and vote on the views, and then provinces will have a chance to whether they agree with what we say or not when they consider their final mandates. So now, for now, we are free to express your views and vote according to your views on the.
So, Chairperson, if I understand it correctly, this discussion today will form part of our report that goes back to the provinces, and then they come back with their final negotiating mandate. Is that correct?
Not negotiating, final mandates. So they won't be negotiating.
Yeah. Yes. So we're negotiating now, and then we send them a report, and they come back with their final position. Okay, I understand. I understand that, Chair. That helps a lot. That helps our position a lot. Thank you very much. Yeah.
Okay, thanks. Honorable Matebula? I see the hand of Honorable Matebula.
It's a legacy hand, Chair.
Is it? Oh, okay. Can we ask to drop it? Oh, thank you so much. Can we then, honorable members, with the explanation, those who vote in favor of accepting the amendments as proposed by KwaZulu-Natal and Gauteng and agreed by DTIC and CLSO as a recommendation to the committee? Can we raise your hand, those who vote in support? Honorable Landsman, you can indicate.
Support, Chair.
Yeah.
I support, Chair. Can you hear me?
Thank you so much, Honorable Landsman. Mr. Solomon.
Thank you, Chair. In support, we have Honorable Moimang, yourself, Honorable Khai, Honorable Mashodi, Honorable Dango, Honorable Mamrahana, and then we've also got Honorable Landsman as indicated.
Thank you so much. Can we ask the honorable members to lower their hands? Thank you very much. Can we have those who vote against the acceptance of the clause? Ms. Solomons?
I don't see any hands against, Chair.
Okay. Those who are abstaining, can they raise their hands, please? Ms. Solomons?
Chair, we've got Honorable Bratuseth, Honorable Lant, and Honorable Matebula.
Okay, thank you very much. That means the vote has been carried. Thank you. We moving to the next one, the broadcast. Let's go up, Mr. Bazia. Go up, up here. Okay. On the broadcast, it says return the current definition of Broadcast and Copyright Act, that's Gauteng 1978, and delete clause 1D. The current definition of the Broadcast and the Copyright Act is as follows. Broadcast, when used as a noun, means a telecommunication service or transmission consisting of sound, images, signs, or signals, which A, takes place by means of electromagnetic waves of frequencies of lower than GHZ transmitted in space without an artificial conductor. And B, it is intended for reception by public or sections of public and include the emitting of programs carrying signals to a satellite, and when used as a verb, it shall be construed accordingly. That's what Gauteng says. Northwest says it is also not clear if the term public reception in the new definition would capture subscription broadcasting services which only broadcast to sections of the public. The current definition of broadcast in the Copyright Act refers specifically to internet reception by the public or section of public. It is not clear if the definition is meant to expand the definition of broadcast to encrypted signals provided on the wired platform, such as the mobile platforms or inline platforms, and thereby include such online video distribution services such as Netflix or Showmax within the ambit of being a broadcasting organization for the purpose of the bill. Can you move up? No. Okay, move up up your cursor. Not down, Mr. Bazia. Up the screen. Okay. In terms of the proposed amendment, proposed delete the amendment to the definition in the bill so that the definition in the Act is retained. That is delete clause 1D of the bill. So the response of the DTIC says the recommendation to retain the current Act can be supported. There were extensive debates in the Portfolio Committee on wire implications and the implication for the industries and the policy considerations underway. White paper, there are policy challenges that were identified. The broadcast definition was intended to cater for various transmissions and meet the treaty obligations. The concern raised that it may exclude other forms of transmission is noted for further consideration. There's a white paper being finalized. The deliberation in the Parliament look at the implication of the wire transmission. Okay. Concerns were raised about the implication of removing wire. There were concerns raised about the terms used in the definition of the bill, such as wholly or partially. With the amendments, concern was that now it omitted satellite transmission and program carrying signals. The wire transmission is still taking place in South Africa. Removing wire may have unintended consequences for a vast number of industries still utilizing the mode of transmission. CLSO consulted the PC on the issue of broadcast, and specifically in respect of wire, we received feedback from eMedia, MultiChoice, NAPSA, SABC, inclusion of wire in the definition of broadcast in South Africa. The two main broadcast platforms are satellite and terrestrial or wireless. There's nothing in law preventing cable broadcasting being introduced into South Africa at this point, but the existing extent of terrestrial or satellite broadcasting services and capital outlay associated with cable rollout means it's unlikely that any party in South Africa would seek such broadcast license at this stage. Can you go down? Just show me where you are in terms of your cursor. Or late at this, where did I stop? The proposal is that the proposal is that this word be included. Broadcasting can happen by way of wire, although what could be regarded as broadcasting by wire in South Africa at the moment is not currently subject to licensing requirements. These licensing requirements may, however, change in the near future. The word wire may refer to a number of types of broadcasting. Cable, which is used in the USA and Europe, because of course, perhaps not likely in South Africa. Internet protocol television. This is a offered. Okay, let me wait for you. This is offered over optical fiber private networks, that is internet broadband services bundled with television services that are offered using internet protocol over private networks in gated estates, hotels or apartment buildings. There are such services in South Africa at the moment. However, no broadcasting license is yet required for this type of broadcast, as it is provided by third parties who bundle internet broadcast services together with the simultaneous retransmission of the channels of existing broadcasting licenses via servers based in the estate, hotels and apartment blocks. Technically, these services will require a broadcasting license if they are offered television services that were not those of the existing broadcasting licenses. As far as NAB is aware, such license application can be made to ICASA, as these IPTV services offer, in the main, mere simultaneous retransmission of the channels of existing TV broadcasting licenses via servers and private networks based on gated estate or in apartment buildings. Therefore, a license is only required for the internet provision, that is an electronic communication services license. ICASA has in fact already looked into this and is of the view that deepening of how this service is structured, it may require a broadcasting license, a fiber optical network, that is the internet in South Africa. All broadcasters are currently providing channels over the top, the OTT, using the internet in one form or another. Streaming services are also provided via the internet in this manner. This type of broadcasting by wire is not yet considered as being broadcasting for the purposes of having to obtain a license. Department of Communication and Digital Technologies is currently busy with a white paper that will bring this type of broadcasting under the licensing framework set by the Electronic Communications Act. It seems it will be classified audiovisual content services, of which broadcasting will be subcategory. Advocate Fanamembe.
Thank you, Chair. What you read out now actually just shows what the industry's views were on this definition in the bill. And mainly it seems that the big issue was in respect of retaining the word wire simply to future-proof the bill. However, the department responded that they agree with the proposal from the provinces to rather delete the definition in the bill, and then, so in other words, retaining what is currently in the Act. And mainly the reason for that is that there is quite a lot of uncertainty in the industry about this at the moment. And there's also a definition being developed by the communication sector, which would probably be a better option to look at in the near future. So just from legal side, if the committee decides to retain the definition in the bill, then we would recommend that the word wire is also retained. But if the committee decides to go with the province's proposal to retain the Act's definition, then we will just delete this definition in the bill in total. Thank you, Chair.
Thank you so much. With that explanation, any addition, Dr. Masot?
Chair, there is a lot of consideration that is required following the public submissions and the possible unintended consequences, especially on the modes of transmissions that might be omitted in the new definition. And even on the issues of the concepts that are in the new amendment, there are concerns around that. I think Northwest mentioned one of them about the reception. So we think that the original definition in the Act can be retained while the other work is being dealt with industry and other departments. Thank you, Chair.
Thank you so much. There is an explanation, honorable members. I don't know if there's a quick, oh, I saw the hand of honorable Protestant. I don't know if he, oh, it's on down.
There was a mistake, Chair. Thank you, Person.
All right, thank you so much. With that explanation, honorable members, can we have those in favor of the close on broadcast raise their hands?
Just clarity, Chair, before we vote.
Yes,
just clarity.
Well, on broadcast,
yes,
there was a proposal that
because look, the department is saying that the recommendation is that we retain the definition in the current Act to be supported. We are voting on that.
You're voting on that, yes. That we support that. The current one in the Act must be retained, because with the earlier definition, there's a lot of that is taking place that must be considered. There are other legislation that belong to other departments, like Department of Digital Technologies, that must deal with such issues. So in the meantime, the one that is in the current Act must be retained. So that is a proposal. Yes. Okay. Honorable Landsman. He's raising his hand now. Thanks very much. Okay. Ms. Madia.
Yes, thank you, Chair. In support, we have Mr. Dango, yourself, Ms. Mashudi, Mr. Landsman, Mr. Moimang, and Ms. Mamarahane.
Okay. Can we now lower our hands, honorable members, those who vote in favor? Can we have those who vote against? No.
I do not see any hands against, Chair.
Okay, those who are abstaining?
We have three. We have Mr. Browderseth, Ms. Matabula, and Mr. Lant.
Okay, so the question is agreed to. Thank you very much. Can I ask the Content Advisor to read the next clause on commission, just what the province is saying, and then we allow Advocate Van der Merwe to and Dr. Masocha to summarize the response without reading. Just read what the provinces are saying, Lutumo, and then the Advocate and Dr. Masocha will summarize the responses. Honorable Dango was right. I need lots of water. Is
Chair,
Lutum on the platform?
Chair, tongue in cheek, I mean, that's what the Western Cape has said. This is a badly worded piece of legislation. If it was better worded, you wouldn't need a drop of water at all.
Noted. Is Lutum on the platform?
Yes, he is. Yes, he is, Chair. But if I can maybe assist,
Okay.
under, if I can maybe just assist, under commission, the proposal from Gauteng is add definition of commission. Define the term commission as meaning the commission established in terms of Section 185 of the Companies Act. And then if we can maybe just hand over to the CLSO and DTIC to respond.
Thank you, Chairperson. So what we are saying here is that the word commission is defined in the Intellectual Property Laws Amendment Act. Now, that is the act that is not yet operational. However, what we have done in the bill is that there is a transitional provision in clause 39 sub 2, which provides for an interim definition for commission. So in other words, there is no need to add commission to the act as a definition. It has already been added. And to deal with the fact that it's not yet operational, there are transitional provisions. So our recommendation would be that it's not necessary to add a definition of commission. In fact, if we add it, the Act will end up with two definitions for commission, and therefore it is not recommended to add a definition. Thank you, Chair.
Thank you so much. Honorable members, with that explanation, can we then vote? Those who vote in favor of the recommendation?
You forgot Dr. Masocha, Chair.
Oh, sorry. Thank you very much. DDG?
Thank you. I thought it was okay that Chair left me out as well, because we are saying the same thing with some variation here and there. The same explanation that advocate has provided is the same from the department. Thank you.
Thank you so much. Sorry for that. With that, with those explanations from Dr. Masocha and Advocate Fanemeve, can we then vote? Those who vote in favor can please raise their hands. Over to you, Ms. Solomons.
Yeah, thank you, Chair. We've got in support, we've got Mr. Dango, Ms. Mashudi, yourself, Mr. Hai, Mr. Moimang, Mr. Landsman, and Ms. Mumrahani.
Thank you very much, Ms. Solomons. Can we please lower our hands, honorable members? Those who are voting against?
I don't note any hands, Chair.
None. Okay. Those who vote, or those who are abstaining?
I note two hands, Chair, Mr. Lund and Mr. Bratisek, and then on the third hand is Ms. Matavula.
Thank you very much. So the vote is carried. Thank you very much. Can you take us to the next one, dramatic works?
Okay, thank you, Chair. Under dramatic works, we've got a legislative proposal from Gauteng, which proposes the following separate standing definition for dramatic works be considered, as well as that the term is added as a separate concept throughout the Copyright Amendment Bill. Copyright work means any piece of recitation, choreographic work or mime, the scenic arrangement or acting form of which is fixed in writing or otherwise, and any compilation of dramatic works. Then I'll just hand over to the CLSO and DTIC to respond.
Chair, on this one, if I may hand to the department, because from our side, we do not have a comment on dramatic works. I think there was a concern from their side. So if I may hand over to the DDG, thanks.
Yes. DDG?
Thank you, Chair. Thank you, Advocate. From our side, we considered the amendment, and we also considered the concern from the industry about the unique characteristics that they have. However, we also noted that this may require further consultation and further work. Our initial reaction was to say that it could be considered now. This requires a process in terms, because it was not in the amendments before, and it's quite substantive when one looks at it, and in terms of other possible amendments in the CAB. And we think that it requires a proper consideration, but then at the same time, acknowledging that what the industry is raising is very important. So I will say that we think that we will be looking into this further with further consultations, and also looking at implications for the Act when taking it into other possible consequential amendments. Thank you, Chair.
Thank you so much. With that explanation, honorable members, can we vote? Those who...
Sorry, Chairperson, I have a question.
Yes. You can
the department has conceded that further work is needed on this particular clause. I agree, and I welcome their excuse me, Chairperson. I welcome their willingness to do so. It just occurs to me that obviously having to do this extra work, which includes, by their own admission, interaction with stakeholders, that may be another whole process at the same time. So the question is when do they intend embarking on such a process of further stakeholders to engage with them, and will those stakeholders be allowed to make submissions to us? Because it seems to me to make sense that their process of engaging with the stakeholders and our engagement with the stakeholders as well will require that information gets included in our final report, which goes out to provinces before provinces can come with their final mandates. So I would just like to have some discussion around that process and what form it will take, and when we intend to start embarking on this particular interaction on this particular clause. Thank you very much, Chairperson.
Thank you, Honourable Professor. I think what she means, Honourable Professor, is that this legislation, if we pass it, we will pass this legislation without this definition of dramatic works. In principle, they agree to it, but it has other implication in the body of because it's not just the definition. It means therefore there will be other areas within the body of the legislation that we will have to also amend with not just the definition. So therefore, what she means is that after the legislation, this bill has been passed into an act, then as it is their normal work to review all the legislations that are under this department, they will review the Copyright Act, because it will be the act then. They will review and see what other clauses or sections or provision need to be amended, and then this dramatic work will be one of them that they will then include in future amendments. They don't. When they say the future work, it doesn't necessarily mean it will be part of this current amendment. Is that what you try to explain, DDG?
Exactly, Chair. You captured it properly. Thank you.
Yes. Those are the issues that were raised by Honorable Lond last time, that when she says in future, she means future amendments, not within this current legislative process that we're dealing with. You can make your follow-up, Honorable Professor.
Thank you, Chairperson. It just occurred to me that doing so is literally the example of kicking the can down the road. And so we can have amendments on amendments on amendments and just a whole range of bills. And shouldn't we rather just pause for a second and get it right the first time? Or are we going to have a whole plethora of these bills coming through over the next 7th Parliament, 8th Parliament, because we didn't get it right the first time here? Maybe we should just concede that this is poorly written and that we should just try and fix it now and get it done once and for all. Surely that makes more sense. And also, Chairperson, surely it leads to a vast curtailment of resources. I'm expressing myself very badly this morning, Chairperson, but surely we as parliamentarians should be concerned about wasting resources. And if we're having amendment bill after amendment bill after amendment bill, as a result of this and not doing our job properly the first time, we're just wasting the resources of the South African taxpayer who hold us to account and look to us to make sure that their money is properly spent. I'm just very concerned about this, Chair, that we're not pausing here, taking the advice of the provinces and the department on board and just saying, well, we'll just push through anyway and just, and just to hell with the rest and see what happens in the future. Maybe there's some members on this committee that won't be here in the 7th Parliament, but I certainly hope to be. And I would like to not have to be dealing with this, for another 5 years.
Honourable Professor, that's the nature of the legislation. It's the nature of legislation. You have a legislation, and then you review the legislation, you find out there are unintended consequences, and then you amend. So amendment is not necessarily a waste of resources. It's part of the legislative process. But in what she's explaining is that it would mean, it would include other issues that come from the review. And that process will first be done in the department itself, and then they will have to consult, and then it must go to a cabinet as an amendment bill, and then the cabinet approves it for public consultation, and then it must go to NEDLAC, and then from NEDLAC it must then go back to the department, and you have those issues of socio-economic impact assessment, and then go back to Parliament, to Cabinet, and then Cabinet approves it and said, yes, you can now take it back to Parliament. And then it's tabled to Parliament, it goes to NA, and then go to the NCOP. So that's what it means. So it can't just be because we're already dealing with this process and just be part of this process. It is an issue that they will have to consider when they make amendments. I know that it would seem like it's a matter that we can then deal with it now, but it has its own processes as well, because it won't be only this dramatic work. Maybe there will be other issues as well. There were a number of them that I think Honourable Lont raised last time, but all those issues, because they are not part of this bill, they need to go through another particular process, because if you don't do that, then another person can take the department to court, or even ourselves to court for bringing in things that were not part of the bill initially, good as they may be. But that's the nature of the legislative process. Okay. Honourable members, we were to then vote on the issue of dramatic work, that it cannot be included for now. It's a matter that will have to be included in the processes in future. Those who are voting in favor, can they please raise their hands? Ms. Mandia, over to you.
Yes, Chair. In favor, we have Honourable Moimang, Honourable Mamarahana, yourself, Honourable Hai, Honourable Mashuri, Honourable Landsman, and Honourable Dango.
Thank you very much. Can the honourable members please lower their hands? Those who voting against?
I don't note any hands against, Chair.
Okay. Those who are abstaining? Ms. Mandia?
Yes, Chair. In terms of those abstaining, I've got Honorable Lont and Honorable Bratasev.
Yeah.
Oh, and Honorable Matavula.
Yeah. Honorable Matavula. Okay. That means then the vote is carried, honorable members. Thank you. Let's go to the next clause, performer.
Okay, Chair. Under performer, we've got the legislative proposal from Gauteng. The definition of performer should exclude extras in line with the Beijing Audiovisual Performances Treaty and international standard practice. Enrico, if you can please just scroll down, because I just want to check if there's any further legislative proposals from other provinces. Thank you. And then Northwest has also made a legislative proposal that the definition of the word performers is narrow. It is therefore proposed that it be amended to creative so that it can accommodate various categories. Can you scroll down further? Okay, so it was just two provinces, Northwest and Gauteng. I'll hand over to the CLSO and TTIC to respond.
Chair,
Thanks.
I will
Go, Evelyn.
You can continue, Advocate. Just before that, I see the hand of Honorable Bratasev. Oh.
Sorry, legacy hand.
Oh, okay. So, all right. You can go ahead, Advocate Van der Merwe.
Jay, thank you. On this proposal, from legal side, we don't have any concerns. The treaty does not mention extras, but from the department side, they have indicated that we can add it. What we must just mention is that the definition in this bill, in Copyright Amendment Bill, will not change. The definition in Copyright Amendment Bill refers to the Performance Protection Amendment Bill. So the definition in the Performance Protection Amendment Bill is the one that will change. So the voting must perhaps just be clear that in this bill there will be no amendment, but when we get to performance protection, the amendment will then be added. In respect of the proposal to change performers to creatives, this is not recommended. From our side, we would not recommend it. The Act provides for author, that is the word used for all creatives. So whether you're a writer, whether you're a songwriter, when you do lyrics, whether you whatever else is provided for, computer programs, all of those are authors, and that is how the Act then refers to them. And then so there's sufficient provision made for description of a performer. So from our side, we would not make any recommendations in this bill. So no amendments in this bill is our recommendation. Thank you, Chair.
Thank you. DDG?
Thank you, Chair. From our side, we recognized the comments that were made. Also, in terms of the treaty implications, Beijing and the WPPT, we understand that for a performer, the way that is defined is in line with the treaty. And in all fairness, the extras don't have to be in the definition. They are not even in the treaties in terms of the exclusion. However, because this concern has been raised several times, including by the provinces in this process, we think that it will not cause much harm to include it in the definition. So we recommend that it be considered and placed on the definition that extras are excluded. Or such types of incidental performances. But otherwise, we are of the view that it is not a necessary amendment. However, we took into account the many concerns raised around it. Thank you, Chair.
I don't know if
Chairperson, if I may, is the department and the legal department singing from the hymn sheet, or they're saying hymn sheet on this one, or do we have different tones?
sorry, I got kicked out. I don't know what's the process. Mr. Solomon, what is happening now? Because I got kicked out.
Yeah, Dango, your chairperson. Chairperson, I was just wondering whether the department and the legal department for legal officers from Parliament are singing from the same hymn sheet, or they are singing in different tones. I'm now a bit confused on this matter.
Can you hear me?
Network is bad, Chair.
I can hear you, Chair.
Oh, you can hear me? Oh, okay. I still have Honorable Moimang.
No, Chair, I thought there is no confusion in relation to that in the copyright because there is a referral to the performance protection bill. In the copyright, in the current bill, there's no need for amendment because there is, but definitely in the performance protection bill, there will be. I thought that was my understanding. So meaning that there is no contradiction between the doctor and advocate.
Thank you, Honorable Moiman, for becoming a conductor and harmonizing.
Honorable Moiman. Honorable Chair.
Yes, Chair.
Can you take over?
Now.
I have network problems, so I don't know what is the process now because I have problems with my network.
Okay.
Can you hear me?
I think we are at the point where we must vote.
We're voting now.
Yes.
Oh, can you please take over?
Yes, Tim.
Thank you, Honourable Chairperson. Chairperson, I'm concerned that we are looking at two distinct pieces of legislation here, one of which includes extras and one which does not. And I'm concerned that we might have a contradictory situation going forward with this particular legislation, where those wishing to harm the interests of extras who, if you think about it, are just your lower rung actors or actresses that are trying to make a living and feed their families, but they're being discriminated against by interests that are only looking after the bigger stars. And you'll have a situation where they're protected in one act but not protecting the others, and we all know that good lawyers will try and use one against the other. Surely we should have a situation where they're protected in both acts, because if I go back to the evidence given by, or the submissions given by the good professor from Stellenbosch, who said that if I draw a scribble on a piece of paper, it's actually a copyright written artwork. It doesn't regard, it doesn't, the quality of the work is not important. It's just the fact that I did it. So surely we need to protect the rights of extras right across the board, both in the Performance Protection Bill, but also in the Copyright Amendment Bill. And I think that we are creating a huge lacuna here that could possibly bite us or bite South African performers in the future if it ever went to court. Thank you, Chairperson.
No, continue, Chair, because I missed out.
Honourable Lund, is that a follow-up also?
Yeah, I think Honourable Browder articulated that quite well, Honourable Moimang. But I mean, this again comes back, and I'm really worried that we are trying to push something through and not fixing it properly. And I've asked this at the beginning, we've asked it during the process, And now Honorable Khai is struggling with his connectivity, and that also speaks to what we've been asking. Let's have these important conversations in person. But we cannot have such important legislation that we rush it through for whatever reason. And well, chair, both chairs, let's please then make sure we deal with it as Honorable Brother Seth has said, and not have the unintended consequences flowing from decisions we are making now, and that might have a damaging effect going forward.
Thank you, Honorable Lund. Honorable Mushodi, I see your hand is also up.
President, I was voting because the time you sent in for Honorable Khai, you were on the process of voting. Thank you.
Thank you. Let's just probably then give over to, but not the visual and the physical aspect of the question that Honorable Lund said. Let's give over to Advocate and Dr. Masoja, just a reflection on the issues raised by both Honorable Brataset and Honorable Lund.
Chair, thank you. Yes, the thing is that it's not that the two acts will have different definitions. So I've in the comment section, I just quickly copy and pasted what the Copyright Amendment Bill uses as definition for performer, and it refers to the Performers Protection Amendment Bill. So in other words, the definition as it will appear in the end in the Performers Protection Act, that will be the definition that will be applied in the Copyright Act as well. So from legal side, there's nothing that is required for extras to be added. The department has indicated that it would not be problematic to make sure that extras are expressly excluded. And therefore, if the committee then agrees that that amendment must be made, what I simply was saying is that it will not be made in the Copyright Amendment Bill. That amendment will be made in the Performance Protection Amendment Bill. So yeah, it's not that we disagree, it's just that there's a different aspect that a different perspective that we're coming from. And then, like I say, there won't be a difference between the two acts, but the amendment will be made in the one because the other refers to that one. Thank you, Chair.
Thank you, Advocate. Doctor?
Chair, in terms of the point about discrimination and unintended consequences, it is a widely known practice in industry that there are people who perform or who participate in productions, and they are not your typical performer in terms of the ones that would be entitled to your royalties, who are regular performers. These are persons that will be at the background, and they don't do much, or even sometimes they don't even say much in terms of their participation. So they are incidental. Like there will be, let's say it's a group of people who are there, and then they are used for a particular purpose, and that is that. So the issue of discrimination against them, we looked into that, and even in terms of best practice, even with the treaties, they are not in those definitions of performer. And we think that the interest of performers will be addressed in terms of what the Performance Protection Amendment Bill provides for. And we don't think that there will be disadvantage in terms of their rights. Extras are usually not even catered for in terms of where they are mentioned even in a treaty language or even in the text. So it doesn't mean that they're not important. And that's not what we are implying with the suggestion. The context where we are coming from as a department is that we have the same view as the legal services in the parliament in terms of the way that they look at the performer and the way they explained it. So we're not contradicting each other. The only consideration we have taken is that because it has been raised a few times, and it seems like it's a concern, although we think that it should not necessarily be amended because it's something that can be dealt with without it being in the legislation. So we thought that we could consider it for the purposes of addressing that concern that has been repeatedly raised, and also in this process by the provinces. So we don't see that this exclusion as a discrimination or exclusion for performers. Thank you, Chair.
Thank you, Doc.
Chairperson.
Yes, Tim?
Chairperson, I must say that I found the last expression of opinion highly offensive. We live in a South Africa where we have a constitution that protects the right of all South Africans. It protects their right to make a living. It protects the right to feed their families. And we've had a representative now just saying that extras are incidental. They're not really important. They don't do much. Well, you know, let's go out to all the extras in South Africa who make a couple of R100 here, 1,000 Rand there to try and survive, and tell them that they're incidental. They don't do much. They're not important. And basically we're creating these rungs of performers. And, you know, you lot down there are just, you know, you're not important. We don't really care about you. We can replace you with CGI, so who cares? And, you know, I just found that incredibly offensive. And in fact, I asked that you should rule against that and ask that particular person to withdraw those statements. I have family members that have been extras in various productions. And for them to hear that they're incidental and don't do much and aren't really important and not catered for, that sort of language is incredibly offensive in South Africa, and we should reject it with contempt. Thank you, Chair.
Thank you, Tim. Honorable Boshoff?
Thank you very much, Chair, and sorry for joining in late, but I was able to make it. I just want to say I concur with what Honourable Bartosz said. That's how I also feel. And we cannot have somebody from the Department of Legal saying that we do not think it will be of concern to them. These type of things were raised as a concern by various provinces. So we should actually really have a look at it to see to it that the extras get their due diligence. Thank you very much.
Thank you, Chair. I thought, but of course I'll give over to Dr. Masoza just to give more context, I suspect, because I thought the issue is in the Copyright Amendment Bill. There is the amendment is not recommended, but there is referral to the Performance Protections Bill, which will mean that probably this discussion will be more pronounced when we deal with the Performance Protection Bill, because I think that was my understanding from what both the advocate and also the doctor said. Maybe just give them back and then we'll come back. Chair? Hi?
I hope you can hear me, Chair.
I can hear you adequately so.
Okay, thank you so much. I think just to explain, it is not the department that came up with a proposal to exclude the extras. Actually, it's the provinces themselves. And she was explaining that this thing kept on coming up even in the public hearings, and therefore they have considered it and they feel that then it should be included. So it came from the stakeholders themselves that they must be excluded in terms of the definition. I just wanted to clarify that aspect. Thanks.
Thank you, Chair. I think we must now vote on this aspect. Those that are in favor, let's vote that we do not recommend amendment in the Copyright Amendment Bill. Ms. Solomon?
Chair, I've got 6 hands up in favor. I've got Honorable Mashuri, Honorable Dango, Honorable Mamaragana, Honorable Hai, yourself, Honorable Moimang, and Honorable Landsman.
Thank you, Ms. Solomon. Can members lower their hands? Those that are against? Honorable Langsman, can you take your hands down? Those that are against? Those that are abstaining? Yes, Ms. Solomon.
Yes, Chair, abstaining, we have Honorable Bratiseth, Honorable Lont, and Honorable Matabola.
Sorry, Chair, I can't put up my hand. I'm also abstaining. Thank you.
And then we've got Honorable Boshoff as well, Chair.
Thank
There
you,
we
thank
are.
you.
It's gone up now.
Ms. Solomon. Thank you, Sonia, for getting it right. So therefore, the votes carries the recommendation through by 6, and those that are abstaining is 3. Can we then ask members to take their hands down, and then we move to the next definition, Ms. Solomon?
Yes, thank you, Chair. Chair, and the person.
Yeah, can I interrupt? Can we?
Yes, Honorable Dango.
Can we consider a 5-minute break at some time?
Yes, I think it's a fair and reasonable request. Do you want us to take it now, Honorable Dongo?
If we can, yes.
Yes, let's do that. Just 5 minutes break.
Thank you, Chairperson.
Thank you. Honorable members back. We can resume.
Back is chairperson.
Thank you, thank you. Honorable Khan?
I'm back, Chair.
Yeah, you can proceed again.
I don't know if I want to have a challenge again.
Yeah, no, if you have a challenge, I'll step in. Just that
I have a problem at home with some people are trying to violate my rights. So I just want to attend to the matter. I'll log on back.
Okay. All right. Okay, let's continue then, Ms. Matia.
Okay, thank you.
We're on the sorry. Is everybody back?
I am back, Honorable Chairperson. Thank you.
Okay, thank you so much.
Okay, thank you, Chairperson. Under person with disability, we've got two legislative proposals, one from Gauteng and one from Northwest. From Gauteng, the proposal is no change required to the definition of persons with disabilities, as the breadth of the definition fulfills South Africa's Bill of Rights and international disability rights obligations. Under Northwest's proposal, the definition of persons with disability in the bill read as including a person who has physical, intellectual, neurological, or sensory impairment that is any disabilities, as opposed to limiting such persons to those hold or manipulate the book as a result of physical disability as provided for in the Marrakesh Treaty and approved by the Constitutional Court. It is therefore proposed that the definition be extended to other disabilities, including deafness, deafblindness, dyslexia, etc. Moreover, that sign language is due to become an official language. The section will also accommodate the deaf community. Then I'll hand over to the CLSO and DTIC to respond.
Yes, please.
Thank you, Chair and members. We agree with the proposals from the Gauteng province that there's no amendments necessary. And we can just confirm in respect of the proposals from the Northwest that in fact the definition does provide for all persons with disabilities that is required by our Constitution. So there are no amendments required. Thank you, Chair.
Thank you so much. DDG?
Thank you, Chair. Same as the advocate, no comment on this one.
Okay, thank you so much. Honorable members, with that explanation, can we then vote? Those who are voting in favor, can you please raise your hands? Ms. Madia?
Yes,
Chair, can you see my hand?
Yes, we can see your hand here. Thanks, Honorable Landsman.
Yes, Chair. Thank you, Chair. We've got Honorable Moimang, Honorable Mashodi, Honorable Dango, yourself, Honorable Khai, Honorable Mamrakhane, and Honorable Landsman.
Thank you so much. Can you please lower your hands, honorable members? Honorable Mamrakhane, Honorable Landsman, can you please lower your hand? Oh, thank you so much. Those who are voting against the proposal? None. Those who are voting, or those who are abstaining?
Chair, I've got Honorable Bashoff, Honorable Bratusef, Honorable Matabula, and Honorable Lunt.
Thank you so much. The recommendation then is accepted. Thank you very much. Can we then move to the next one, the producer?
Okay, Chair, thank you. Chair, under producer, we've got one legislative proposal from Gauteng, which reads producer in relation to a sound recording when audiovisual work means the person by whom the arrangements necessary for the making of the sound recording audiovisual work are undertaken. And then I will hand over to the CLSO and DTIC to respond.
Chair, the word producer is not used in the Copyright Amendment Bill or in the Copyright Act. So we suspect that it was put in the wrong mandate, and it can be dealt with in the performance protection side if it was repeated there, because we are bound by the mandates. But in the Copyright Amendment Bill or the Copyright Act, we would not recommend the inclusion of a word that is not used in the Act. Thank you, Chair.
Thank you so much. Advocate, DG.
Yes, Chair. We found the comment unclear and without a specific legislative context to place it. So it's I agreed with the advocate. Thank you.
Thank you very much. So, honorable members, the proposal, Honorable Bretese.
My apology, Chair, that was a mistaken hand.
Okay, thank you so much. Honorable members, the proposal is that this inclusion of the term producer should not be included. Those who agree or in favor of that recommendation that must not be included, can you please raise your hand?
Okay, thank you, Chair.
Is my vote recorded?
Yes, Mr. Lansman.
Yes,
so as Chair, in terms of voting, we have Honorable Moimang, yourself, Honorable Khai, Honorable Mashodi, Honorable Dango, Honorable Mamahana, and Honorable Lansman.
Thank you very much. Honorable members, can you please lower your hands? Honorable Lansman, can you please lower your hand? Thank you so much. Those who are voting against? None. Those who are abstaining?
Chair, in terms of those abstaining, I've captured Honorable Boshoff, Honorable Matavola, and Honorable Lunt, and Honorable Brantesev.
Okay, thank you so much. So the vote is carried. Thank you so much. We go to the next one, technological protection measures, and the technological protection measures, circumvention device and service.
Okay, thank you, Chairperson. Chair, and the technological protection measure and technological protection measure circumvention device and service, we've got legislative proposals from Gauteng and Northwest. In terms of Gauteng, the proposal is definitions of technological protection measure and technological protection measure circumvention device and service are not compatible with Article 18 of the WPPT, and the exceptions in Section 28P relating to prohibited conduct in respect of technological protection measures are inadequately defined, therefore rendering them incompatible with the three-step test. Section 1, K, by insertion after the definition of sound recording of the following definitions: technologically protected work means a work that is protected by technological protected measure. Technological protected measure means any process, treatment, mechanism, technology, device, product, system, or component that is in the normal course of its operations is designed to prevent or restrict infringement of copyright work. Technological measure circumvention device or service means devices, products, or components for the provision of services which are promoted, advertised, or marketed for the purpose of circumvention or have only a limited commercially significant purpose or use other than to circumvent, or are primarily designed, produced, adapted, or performed for the purpose of enabling or facilitating the circumvention of any effective technological measures From the Northwest, the proposal is the definition of technological protection measures, a circumvention device are not compatible with the WPPT requirement to provide adequate legal protection and effective legal remedies against the circumvention of the effective legal remedies. Moreover, the exceptions in relation to prohibited conduct in respect of technological protection measures are insufficiently defined, therefore rendering them incompatible with the 3-step test. Gauteng makes further recommendations that the lack of definition of wire and wireless could lead to confusion and interpretation issues. In addition, while internet access is referred to in the Memorandum of Objects of the Copyright Amendment Bill, it is not specifically referred to in the relevant sections, which could result in interpretational issues for the creative industries and the users of copyright works, which are especially concerning given their financial obligations. And I will hand over to the CLSO and DTIC to respond.
Thank you, Chairperson and members. On technological protection measure and circumvention device and service, the proposed wording was in fact advertised in the Portfolio Committee and consulted with the public on. And the outcome from the public consultations were that it was significantly affecting various aspects of the economy in South Africa. And accordingly, the recommendation from our office's side is that the current definitions in the bill be retained as they are. They were thoroughly tested, they were thoroughly consulted on. Like I say, they have in fact been made stricter, and it showed that it becomes unbalanced if we make it more strict. The current proposed amendments are providing a very careful balance between the rights of your copyright owners and the rights of users. And it is also our submission that the way they are worded, they do comply with the 3-step test and of course constitutionality. Thank you.
Thank you so much. DDG, Masoj?
We looked at them, Chair, even at the National Assembly, and they were party to extensive consultations. And what came out of that process was a need for that balance that advocate is talking about between access and ensuring that there is that protection. And there were also many unintended consequences that experts picked up with the stronger technological protection measures. So we support that these definitions be retained as they are in the current bill. Thanks.
Thank you so much. I see the hand of Honorable Lont and Honorable Brotherset. I don't know if they are.
Sorry, Chair, that one hand of mine should have been lowered. I'm taking it down now.
Okay. Honorable Brotherset.
Yes, thank you, Chairperson. Chairperson, you know, the CLSO and the DCRC referred to consultation with experts and this being workshopped extensively, but I do not remember as a member of this committee being party to any of those consultations or interactions on the TPMs. And so my question simply is can we please get a detailed breakdown of the interactions and consultation with all these so-called experts on this so that we can have an understanding of it, because it seems that the representations from Gauteng and particularly Northwest seem to be quite detailed, go into quite a lot of, will provide quite a bit of information and question whether or not this particular definition is aligned with certain treaties. So could we just please have a full explanation of what interaction there was, and not just a referral to, well, we spoke to experts. We'd like to see what the discussions with the experts were and an understanding. Otherwise, as I suspect, we're just going to blindly vote for or against this and not actually understand the entire issue about these TPMs. Thank you, Chairperson.
Thank you, Honorable Professor. I think my understanding is that it refers, firstly, remember at the start we had a workshop before we even receive a briefing from the DTIC on the 2 bills. We had a workshop that was facilitated by Advocate Van der Merwe. We invited experts from universities and I think NGOs, and I think there was a retired professor also will take us through the copyright bill, not necessarily the bill, the copyrights with all its provisions. And then we had public hearings ourselves as a NCOP. Unfortunately, I was not part of the public hearings due to illness. But I understand that there were those public hearings, and then there were responses from both the department and the CLSO. And after there were also public hearings in provinces on the bills. But I will allow advocate and DDG to respond on the issue of consultation and the views of experts. Advocate.
Thank you, Chair, and thank you to the members. Chair, yes, when we responded the first time to submissions, I did provide a couple of slides setting out the type of consultations, the names of experts that were consulted in the whole process, because these bills come from quite a lengthy process. And then I must just also indicate, in respect of this specific technological protection measures now, I summarized advice that have been given before, where I went more in depth into why we would not recommend that this be changed because of the balance that it keeps. And in fact, the need for that balance is in the 3 points that are currently on the screen, because too strict measures on technological protection measures, if you make them too strict, they affect freedom, certain freedoms, the freedom to arrange our conduct to our own benefit. And that means that if I want to take my Renault to the mechanic down the road, I must be able to do so. It's my Renault. I don't have to be forced to take it back to the Renault garage, because only the Renault garage can read the computer in my vehicle. The second freedom is of third parties to offer accessories. So if my mechanic wants to be able to provide me with a certain part for my Renault, they must be able to do so. It shouldn't be something where I have to go back to the Renault manufacturer simply because there's a technological protection measure in the engine of my vehicle that makes me unable to go to any other person. And then, of course, the protection, the freedom of auditors to uncover and publicize defects, because if they cannot disclose the technological protection measure, or if they can't access the products through that technological protection measure, they can't actually audit. And this is especially important for developing countries. The concern, the freedoms that I'm raising concerns about, raise concern in the USA, which is a developed country, and even there, these concerns are currently a massive topic of debate, and the caution that was made to all the committees and from the public as well, when the public was consulted on this, is that we must be very cautious about making our technological protection measures so strict that it stops the economy from operating in this way because of these freedoms being affected. And that then came through in consultations that were held in various committees. I hope that clarifies, Chair. Thanks.
Thank you so much. DDG Masocha.
Thank you, Chair. Also, in other literature that we consulted from other countries, in terms of those who took stronger technological protection measures into account, they had those consequences that we noted, and we also felt that it is important that we take that into account to ensure that the bill addresses a balance between the rights of the users and the copyright owners, and ensuring that there is that adequate protection, but at the same time there's access to the works. Thank you, Chair.
Thank you so much. I hope that is clarified. Honourable members, we were about then to vote on the issue of technological. Can we have those in support? Please raise their hands.
Yeah. Thank you, Chair. Chair, I have voting Ms. Mashodi, Honorable Mashodi, Honorable Moimang, Honorable Dango, yourself, Honorable Khai, Honorable Mamarahana, and Honorable Landsman.
Okay. Okay, honorable members, can you please lower your hands? Honorable Landsman, can you please lower your hand? Thank you. Those who are voting against, can you please raise your hand? None. Those who are abstaining, can you please raise your hand? Okay.
Thank you, Chair. Abstaining, we have 4, Honorable Boshoff, Honorable Lunt, Honorable Matavula, and Honorable Bratasif.
Okay. Thank you so much. Can you please lower your hands?
Okay, thank you, Chairperson. Moving on to clause 2, section 2A, scope of copyright protection. We've got one legislative proposal from the Northwest, which
Sorry, Sorry, can you ask Honorable Lunton, Honorable Bratasif to lower their hands? Unless there's a issue. Oh, okay. Now that we're done with the definitions, I think we will deal with those that there were no negotiating mandates on when we deal with the e-list as well. Now we're dealing with section 2, clause 2. I want to suggest that we just say clause 2, section A, and then we allow the advocate and the DDG to summarize without necessarily reading what the provinces are saying, because it's clear just to summarize. Because I'm looking at the time, I'm not saying we're rushing through, but was at least at 12:30 or 1:45, we should be done for this first part, so that we are able to be part of the plenary session. So can we agree, members, that we will stop at 12:30 for today? Is that fine?
Chairperson. Chairperson, I just want to raise one other matter that's not on this thing. It's the question of the overseas travel.
Can we hold on that? I think there's a topic that is done on the WhatsApp, so we will maybe discuss it in the, if we don't have time today, we'll discuss it in tomorrow's committee meeting.
Okay, fine, thank you.
Okay.
Chair, sorry, I was just alerted that there was something that I missed under the section that one final section. There was an additional proposed legislative amendment from Gauteng in terms of the definition of wire and wireless share. My sincere apologies, Chair, I missed that. Can we can I just read that out and then just have the DTIC and TLSO respond to that, Chair?
Wasn't it also part of the broadcast, explained there under broadcast?
It was under technological protection measure, Chair.
Yes, but I think if my understanding is that it was a similar, okay, you can read it out there.
Okay, my sincere apologies, Chair. From Gauteng, the lack of definition of wire and wireless could lead to confusion and interpretation issues. In addition, while internet access is referred to in the Memorandum of Objects of the Copyright Amendment Bill, it is not specifically referred to in the relevant sections, which could result in interpretational issues for creative industries and users of copyright works, which is especially concerning given the financial obligations.
Okay.
Advocate van der Merwe and DTIC.
I will respond on that one. On the definition of wireless and wire, we looked into that, and the consideration was also on the alignment with the treaty language and text. And wire or wireless is used extensively, and even in those texts, they are not defined. And we also looked at it from a context of, can we look at that as a dictionary word, an ordinary word that is in the dictionary? And in that context, we noted that the word wireless is normally linked to your Wi-Fi or commonly used words as such. And because of that, we were of the view that the definition should not be recommended. And so therefore we are saying that we recommend that we don't include the definition in the bills. Thanks.
Thank you. Advocate.
Thank you, Chair. I have nothing to add to this. Yeah, thank you.
All right then. Then we move to the clauses. I mean the section 2A. I was suggesting members, if we agree that we just say clause 2, section so and so, and then the CLSO and the DTIC summarize the responses, and then we take it there, because I'm thinking now we're approaching the we won't be able to finish now, and we are aware that we won't be able to finish now, because that's why we have 2 days set for this process. Honorable Maima.
As clarity, Chair, just on what was put to us, are we not voting on that one? That Maria made
we have voted, but she forgot to read out part of what was it, Gauteng. Can you move up on Mr. Biazia?
It had to do with wire and wire.
Back to the move up, please.
It was that last part, Chair, under definition.
It was last part, but it's part of the technological, what is it? Move
yes,
up.
Yes, it was under that section, Chair.
Yeah, it was under that section, so which we have already voted for. It's just that it's part of this honorable. Just move up, up, not down. It was part of the technological protection measures, and the technological protection measures circumvention device and services. It's just that she didn't read out the other part of the is it Gauteng? Mattia?
Yes, Chair.
Yeah, the other part that was mentioned by the Gauteng in their negotiating mandate. Otherwise, we had already voted on the issue of the definition of technological protection measures and technological protection measures, circumvention device and service. Honorable Moimak. Okay, can we then move to section A? Okay.
Okay, so the proposal here is in respect of computer software interface specifications. From legal services side, we would simply state that it's not necessary to define this. If words have their normal dictionary meaning, we need not define it. The department will speak to the policy behind this. Thanks.
Thank you so much. DDG?
These specifications are not they don't have a copyright subsisting in them. They are used in terms of processes and procedures in the interfaces, and we are of the view that as it is, they're not subject to copyright protection, and we think that for the purposes of what is in the bill, they are sufficient. So the amendment is not recommended.
Okay. Honorable members, those who vote in favor of the recommendation by the CSLO, CLSO and DTIC in terms of this particular clause section 2A1B, please raise your hand. Ms. Solomon, can you please help us?
Yes, Chair. The voting we have Honorable Moimang, Honorable Dango, Honorable yourself, Honorable Hai, Honorable Mashuri, and Honorable Mamirahani.
Thank you very much. Can you please lower your hands, honorable members? Okay. Those voting against the recommendation not to recommend the amendment. Those who are abstaining, please raise your hands. Ms. Solomons.
Yes, Chair. Abstaining, we have Honorable Pasha, Honorable Lont, Honorable Matabula, and Honorable Pratasif.
Okay. Thank you very much. So that means the vote is carried, and we move to the next section or clause. Clause 3. Okay.
Apologies. Thank you, Chair. Yes, this refers to two clauses because it deals with the same thing in the two clauses, clause 3 and clause 24, dealing with local organizations. Chair, on this one, we do not recommend any amendments because the concerns that are raised by the province are already dealt with in the bill. The local organizations will be identifiable. They will be prescribed. And respect of the policy, I think I will just refer to the department. Thank you.
Thank you so much. DDG?
Thank you, Chair. In the Act, we already have international organization as an example of those types of institutions that can have copyright and prescribed. So we have included the local as well to ensure that there is that inclusion. So it is something that will be carefully considered when they are being prescribed, but we understood it to say that there are local organizations that can develop their own copyright that requires protection, and it will not take anything away from the authors who are already providing copyright works in other works. So we think that it's something that will be, it's already attended to in the bill, and therefore we suggest that this not be amended.
Yeah. Honorable Lont.
I do apologize, Chair, that it's me trying to multitask. So okay. I'm dropping the hand.
All right. Honorable Pratasif.
Sorry, okay, Chair, legacy hand. My apologies.
All right. All right. I know there's also that floods ad hoc committee. Yeah.
Yes, that is a problem.
Okay. All right. Thank you so much. Honorable members, can we now, after the explanation, can we vote? Those in favor that there should be no amendment because the issue is already addressed in the bill. Those in favor, please raise your hand.
Okay, thank you, Chair. In voting, we have Honorable Moimang, Honorable Mamirahana, Honorable Mashuri, yourself, Honorable Hai, Honorable Dango, and Honorable Landsman.
Thank you very much. Can you, honorable members, please lower their hands? Thank you so much. Those who are voting against, can they please raise their hands? None. Those who are abstaining, can they please raise their hands? Okay.
Abstaining, Chair, we have Honorable Bashar, Honorable Branteseth, Honorable Matabula, and Honorable Lunt.
Thank you so much. Can you please lower your hands? Sorry. Thank you so much. Then the vote is carried to the section 5.2 and 21.2 of the Act.
Chair, sorry, Chair, if I can just indicate, there is a clause that, clause 4, we also need to vote as a committee on clause 4. There were no legislative proposals from provinces in terms of clause 4. So in the absence of that, can we then just take it, then we still need to vote to accepting the clause as is, even though there were no legislative proposals from provinces.
Okay, because I was saying earlier that when we deal with the E-list, it will be dealing with all of the clauses, including those that were not part of the proposal from the provinces. I don't know if we should deal with it at this stage or we should deal with them when we deal with the E-list. Samara?
So, Chairperson, you broke up, but can you please repeat?
Oh, I was suggesting that if it's procedurally correct, there are clauses where there were no negotiating mandates or amended proposals. I was saying that perhaps we should be focusing on the negotiating mandates, on mandates, proposed mandates or proposed amendments. And then when we deal with the E-list, we will deal with everything, including those areas where provinces did not make amendment proposals. Or should we deal with those even at this stage, those where there are no, for example, clause, is it section 4 or clause 4?
Correct, Chair, clause 4.
Clause 4, yeah. There are no proposals that have been made by provinces in terms of the negotiating mandates. So I was checking whether we should vote on that clauses and at this stage, or we vote when we deal with the E-list in July.
We can vote on the E-list, but I would have to caution the meeting that unless a provision has been contained in the negotiating mandates, it cannot be included in the E-list. Are you saying that the committee is proposing this amendment, Chair? Thank you.
No, we're not proposing the amendment, but in the bill itself, in the bill that is proposed, there is clause 4, but then there's no province that has made any proposal in terms of that particular clause. I assume that as well in the definitions, there are definitions that there are no proposals from the provinces. We have been only dealing with those that there were proposals from provinces. On this one, I'm speaking under correction. Maybe the Samara advocate and TTIC may come in. Just assume that there were in the bill definitions where there are no proposal from the provinces. Or am I mistaken? All the definition are there proposals on all the definitions that are in the bill? Can I first get that clarity, advocate?
Yeah, procedurally, I'm not really the procedural advisor, but what I would suggest and what I would recommend is that the committee perhaps today look at every clause, because when I bring the E-list to the committee, I will not be including clause 4 because there will not be any amendments to it. So I'm just concerned that when we look at the E-list, we might forget that we need to look at clause 4 because we will be focusing on words in the amendment list. My recommendation would simply be for the security of making sure that we have followed the correct process, that we simply, if there's no amendment, we simply vote on clause 4, that there's no amendments proposed. In fact, I'm not even sure that it should be a vote, but that their Advocate Ali will advise, because there are no amendments. So I suppose the vote would simply be adopt as is, because that would be by implication what the negotiating mandate is saying. If we don't propose an amendment, we propose adopt as is. I would recommend that we do so today so that we know all the clauses have been voted on. And when we come back for the E-list, all we need to focus on is the wording of proposed amendments, because that is also very important. Okay. Thank you, Chair.
Thank you so much. But then the question stands as to whether the definitions that we're dealing with, where there were proposals, are there any other definitions where there were no proposals, so that we also vote on those definitions where there were no proposals?
Yes, there were in fact such definitions, and perhaps Advocate Ali can advise, but perhaps the committee can simply vote on clause 1 with the proposed amendments as already adopted. That might be a way out instead of having to vote on each definition, but I think she would be better placed to advise. Thanks, Chair.
All right, thanks. Advocate Ali.
Thank you, Chairperson. I do indeed concur with my learned colleague. It would make sense to adopt clause by clause. With regards to the definitions that are not contained in the bill, the committee will have to take a decision as to whether this definition is going to enhance the bill. We've had previous instances, I think it was a tourism amendment bill, where the word tourism was defined in the bill before the committee, but it didn't make sense for the committee to pass an entire amendment bill without having fixed that technicality. There are procedures involved. If a definition is not contained in the bill, we can apply to the House to have that considered. However, it will lengthen the process. So the committee has to make a decision as to whether we're going to embark on the process where this committee is going to ask permission from the House to include an amendment, or whether you're going to consider the bill as is and leave the amendments for a later stage, perhaps the second amendment bill. But that's a decision for the committee to take. Thank you, Chairperson.
Thank you so much. Honorable Lodge. Oh, okay. Honorable members, can we then go back to the definition? I know we've already moved to clause 2, and now we've just passed clause 3. Can we then vote on clause 1? Because we were voting on the proposals from the provinces and also the responses from just to correct that aspect. Can we then vote on clause 1? Because clause 1 will then include all the definitions, including those that there were no proposals on, just to correct the procedure, so that they are all included when the E-list is made out. Those in favor of clause 1, can they please raise their hands? Ms. Solomon?
Yes, Chair. In support of clause 1, we've got Mr. Honorable Moimang from the Northern Cape, Honorable Danko from Gauteng, yourself, Honorable Hai from the Eastern Cape, Honorable Mashori from the Free State, Honorable Landsman from Northwest, and then Honorable Mamarahana from Limpopo.
Thank you so much. Can they, honorable members, please lower their hands? Honorable Mamarakhane, okay. Those who voting against the proposal to adopt clause 1? None. Those who are abstaining, can they please raise their hands?
Chair, we've got Honorable Lund from the Western Cape and Honorable Brandesef from KZN.
There's also Honorable Boshoff.
Honorable Boshoff.
Yeah, okay. So the clause 1 is therefore adopted. Thank you so much. Thank you, Ms. Solomon, for reminding us. So let's then go to clause 4. Honorable members, there are no amendments on clause 4. I don't know if they are legacy hands. Honorable Lonte, will you please lower your hand unless you want to say something? Oh, okay. All right.
Chair, can I just ask that, seeing as though we went back to clause 1, can we just procedurally go through clause 2 and clause 3, and then clause 4, and then vote in the same manner, just so that we cover ourselves, because we've now voted on clause 1. And I think it would be proper for us to follow the same procedure with clauses 2 and 3. The committees already voted on the responses as to whether or not they've accepted the responses from the CLSO and the DTIC. So it's just a matter of confirming that decision in terms of whether or not they're confirming the decision in terms of those clauses, Chair.
Yeah, no, I agree with you, because there may be no proposal in terms of that clause, but there would be other provisions that we also need to take into account, especially on the E-list. Can we also now go to clause 2? Those who vote in favor of the adoption of clause 2, please raise your hand. Ms. Solomons?
Yes, Chair. In support of clause 2, we've got Honorable Moimang from the Northern Cape, Honorable Mamarakhane from Limpopo, Honorable Mashuri from the Free State, yourself, Honorable Khai from the Eastern Cape, and Honorable Landsman from Northwest, and Honorable Dango from Gauteng.
Thank you so much. Can you please lower your hands, honorable members? Thank you so much. Those who are voting against, please raise your hands. None. Those who are voting against, please, sorry, those who are abstaining. Ms. Solomons?
Yes, Chair, we've got Honorable Lon from the Western Cape, Honorable Boshoff from Mpumalanga, Honorable Brandesef from KZN, and Honorable Matabula from Limpopo.
Thank you so much. The clause is therefore adopted. Let's go to clause 3. Those in favor, please raise your hands.
Yes, Chair. Thank you, Chair. In terms of clause 3, in support, we have Honorable Moimang from the Northern Cape, Honorable Dango from Gauteng, Honorable Hai, yourself from Eastern Cape, Honorable Mashudi from Free State, Honorable Landsman from Northwest, and Honorable Mamarakhane from Limpopo.
Thank you so much. Can you, honorable members, please lower your hands. Honorable Mamarakhane, please lower your hand. Thank you so much. Those who voting against, please raise your hand. None. Those who are abstaining, please raise your hand.
Chair abstaining, we've got Honorable Pasha from Mpumalanga, Honorable Matavula from Limpopo, and Honorable Pratasif from KZN, and Honorable Lon from the Western Cape.
Thank you so much. Can you please lower your hands? Ms. Matavula? Thank you so much. So clause 3 is therefore adopted. Clause 4. Number members, there are no proposals from provinces from clause 4, but we need to decide whether we adopt it or not. Those in favor of clause 4, can you please raise your hands?
Chair, those members in support of clause 4 as is, we've got Honorable Moimang from the Northern Cape, Honorable Dango from Gauteng, myself, Honorable Khai from Eastern Cape, Honorable Mamarahana from Limpopo, Honorable Landsman from Northwest, and then Honorable Mashodi from Free State.
Yes. Thank you very much, Ms. Solomons. Honorable members, please lower your hands. Okay. Those who are voting against adoption of clause 4, please raise your hands. None. Those who are abstaining, please raise your hands.
Thank you, Chair. Abstaining, we've got Honorable Basha from Mpumalanga, Honorable Matavula from Limpopo, Honorable Pratasif from KZN, and Honorable Lund from Western Cape.
Thank you very much. Can you please lower your hands? Honorable Pratasif, Honorable, okay, thank you so much. So clause 4 is adopted. Thank you very much. Let me move to the next clause. Clause 5, advocate, Panama.
Thank you, Chair, and thank you to the members. Chairperson, this, although it deals with one clause, it affects a number of clauses, the proposed amendments. The concern raised by provinces is that the bill is approaching or using a one-size-fits-all approach when it comes to royalties. And they are saying that there are a need for parties to be able to agree to some other form of payment that is not a royalty, that is not a percentage of profit. So the proposal, Gauteng made specific proposals in respect of wording, and then specifically in respect of 6A, but it affects other sections as well. And the department was actually the one who said that they think that there is merit in adding the words equitable remuneration, which is the word used in the Performance Protection Amendment Bill, but to also add that to the Copyright Amendment Bill. And it affects a number of clauses. So I've listed them there for members to see. So what the proposal in the end then would be is, because we can't just do it in 6A. If we do it in 6A, we'll have to do it in other clauses as well, because the same principle applies. And of course, we have that that leeway, because although Gauteng only proposes in respect of 6A, other provinces have proposed in general to say there's a one-size-fits-all in the whole bill. So the proposal is to add equitable remuneration wherever the words royalties is used in the following clauses. And Chair, also, if I can just indicate to members, the way that it will be worded might differ slightly from section to section, simply because of the meaning. So, you know, I've tried to make it the same. I've already drafted some wording in order to ascertain where it had to go. So I tried to put equitable remuneration before royalties, always, but sometimes you need to add a little bit of a sentence just to make sure that it means something. And sometimes you have to separate equitable remuneration from royalties, because the way it will be paid will be different. But it will affect the long title of the bill, the Copyright Amendment Bill. It will affect the sections, clauses 5, 7, and 9, dealing with sections 6A, 7A, and 8A, which is the issue of royalties going forward once the work is sold to someone or used by someone, that there will be continuous royalties paying. It also applied to commissioned work. It will also apply to orphan work, to the collecting societies clause, to the tribunal clause, and to the regulations clause, and the translation licenses, the Schedule 2 clause. So, Chair, that the proposal is that we do make provision for the words equitable remuneration in all of those. Chair, the other proposals from Gauteng was to change the word authorization to, or rather execution to authorization. And the department's response on that is that it is not recommended because your execution is where the royalty will become due. So it's a better word in that sense, in respect of 6A now specifically. Then there was also a proposal to make provision for the tribunal to be guided with certain principles, and the concern that the department raised on this, and I think I also raised that, was that we must be cautious not to take away discretion from the tribunal, because we can't foresee at this point in time what the facts before the tribunal would be. And of course, the tribunal will take into account all factors that might be applicable in this instance. So from the proposals, and it affects Free State, Gauteng. Okay, in fact, it affects Free State and Gauteng in respect of 6A and the equitable remuneration. And the recommendation would be that the only proposal that we recommend would be to add equitable remuneration. In respect of other proposals on this section, Chair, there's quite a lot. So may I just ask guidance, would you like me to go through all of the proposals on this clause, or shall I first just stick to the proposal to add equitable remuneration and guidance to the tribunal?
I suggest that you go to all of them so that when we get to those, we will just put the question to the members whether they accept or reject. Yeah.
Thank you, Chair. Then the next proposal in respect of this clause is that instead of using the words gross profit that is currently used, that it rather refer to turnover or revenue generated. But the department's proposal is that we should not be too prescriptive in the definition of royalty. And it seems that it's preferred for this to be based on profit, because that is where the rationale for a royalty comes. It is about the profit that needs to be shared going forward. There is also a proposal to make the word agreement to read intellectual property agreement. This is not recommended either. And the reason for this is simply that when we look at the phrase in the bill, the subject to any agreement to the contrary is a legal phrase. It simply means that the following will apply unless you reach an agreement that is different. And there's no need to call it an intellectual property agreement. It could be called anything. And I would suggest that we don't be too prescriptive in the act, because it creates loopholes. So for instance, if I now call my agreement a songwriting agreement, does it mean that I can't then exclude it? Must I call it intellectual property before I can exclude it? And the need to be cautious here is just that we need to keep aware that we need to be reminded that especially those who want to protect are not always aware of the words of legislation. There's also a proposal for the percentage to be prescribed, 60% to the artist and 40% to the producer or the company. This is also not something that we would recommend. There was already a big concern about being too prescriptive about contractual arrangements, and to say that it must be this split would definitely be very, very prescriptive and might be argued to interfere with contractual rights. There's also a proposal for sorry, Chair, I'm just quickly trying to read what the next one is. The contractual freedom, to make sure that there is contractual freedom, and we would not recommend that that negotiate alternative terms. It is the same thing that is provided in the bill, in fact, to say subject to a contract to the an agreement to the contrary. But also we need to keep in mind that the rationale for these terms and conditions that are included in the bill is to protect the vulnerable parties that don't have the same negotiation power. There was also an amendment requested from the Northern Cape regarding stricter measures that will enforce government departments to ensure contractual obligations are adhered to. We do not recommend any amendment here. We think this is more an operational matter and probably more an implementation matter. The bill itself does not regulate government departments, but the contract compliance in general, the bill provides for, and that will also affect government departments. So we do not recommend any specific amendment there. Then there's also a proposal from the Northern Cape to shorten the time frame to earn royalties. From the department side, they said that it's not recommended. The time frame should be determined by the parties. And then there was also a concern from the Western Cape about retrospective and arbitrary deprivations of property, and specifically in respect of this clause relating to the retrospective application of copyright. And we do not recommend any amendment. It seems that the province might have looked at an old draft of the bill. The retrospective provisions have in fact been removed. The whole bill only applies prospectively. Those are the amendments proposed in respect of clause 6A. And of course, then just in the beginning, the broad application of equitable remuneration that affects multiple clauses. Thank you, Chair.
Thank you so much. DDG?
Thank you, Chair. We are of the same agreement with the advocate on the changes that she has outlined. Thanks.
Thank you so much. Without the explanation, honorable members, those who are voting in favor, please raise your hand.
Thank you, Chair. In favour, the voting, we have Honourable Dango, Honourable Khai, Honourable Moimang, Honourable Mamahana, Honourable Lansman, and Honourable Mashori.
Okay. Can you please lower your hand, honourable members? Those who are voting against, please raise your hand. None. Those abstaining, please raise your hand.
Chair, abstaining, we've got Honourable Brantaseth, Honourable Boshoff, Honourable Lond, and Honourable Matavola.
Yeah. Can you please lower your hands, honourable members? Honourable Lond, Honourable Matavola. So the vote is carried. I think on the same vein, we will then adopt clause 5 to cater for those provisions that there are no proposals on. Am I right?
Yes, Chair, can we then formally adopt the proposed amendments as proposed by the department and the CLSO too?
Yes, that's what we're doing now. But now we voting on the entire clause 5. Is that correct, Madi?
Correct, Chair. Correct, Chair.
Okay. Those voting in favor of adopting clause 5, can you please raise your hands?
Thank you, Chair. In terms of those provinces voting in favour of clause 5 with the proposed amendments, we've got For the Northern Cape, we've got Mr. Moimang. For Limpopo, we've got Honorable Mamarachana. For Gauteng, we've got Honorable Dango. For the Eastern Cape, we've got yourself, Honorable Hai. For the Free State, we've got Honorable Mashori, and for the Northwest, we've got Honorable Landsman.
Honorable members, can we please lower our hands? Thank you. Thank you. Those voting against, please raise your hand. None. Those abstaining, please raise your hand. Solomon.
Yes, Chair. Abstaining, we've got Honorable Lunt, Honorable Pratusef, Honorable Matabula, and Honorable Boshoff.
Thank you very much. Please lower your hand, honorable members. That means the adoption of clause 5 is agreed to. Thank you very much. The next clause.
Thank you, Chair. The next clause we are looking now, more or less the same situation as with 6A, is 7A. Oh no, sorry, I'm already on the next one, on 8A. In respect of clause 7, the specific sections dealing with resale royalty.
Sorry, colleague. Chair, can we, in the absence of any, because I don't see any legislative proposals in terms of clause 6, can the committee vote in on clause 6, Chair, in the absence of any mandates from clause 6?
Okay, can we do that, honorable members? Those in favor of adopting clause 6, please raise your hands. Okay, Ms. Madia.
Yes, Chair. I'm not sure if Mr. Pratusef has a legacy hand up voting in favor of clause 6 as is.
The legacy hand.
Okay, Chair, voting in favor of clause 6 as is, we've got from Gauteng, Honorable Dango, from the Eastern Cape yourself, Honorable Mamarachana, voting in favor of Limpopo, Honorable Moimang, voting in favor of the Northern Cape, Honorable Landsman, voting in favor of the Northwest, and Honorable Mashodi, voting in favor of the Free State.
Thank you very much, Ms. Solomon. Can we lower our hands, honorable members? Honorable Landsman. Okay, thank you so much. Those who are voting against, please raise your hands. Those who are voting against, Honorable Landsman, please lower your hand.
My phone is malfunctioning, Chair.
Okay. Those who are abstaining, please raise your hand.
Chair, abstaining, we've got Honorable Lunt, Honorable Pratusef, Honorable Matabula, and Honorable Boshoff.
Okay. Please lower your hands. Ms. Matabula and Ms. Honorable Lunt. Honorable members, that means clause 6 has been adopted, agreed to. Thank you so much. Let's move to clause 7.
Thank you, Chair. In respect of clause 7, this is this deals with, like I said, with resale royalties, and the concern raised by the Western Cape was in respect of unique circumstances. If I can refer this to the DDG to respond to, Chair, because it's a policy matter.
Okay. DDG.
Our response on this one, Chair, is that we are of the view that the provision as it is, it can be captured or covered by contractual arrangements between the parties. And our other view is that it may be very difficult to legislate for unknown circumstances. Because if you cover for one, like where the seller is the author is the seller, and we talk about where the royalty is jointly or severally deliberated or dealt with between the parties. So we think that some of those circumstances can be dealt with in the agreements, because should we now look at circumstances and try to deal with each, and specifically the one that has been proposed, it will also be such that the next other circumstance must also be catered for in a different way. So we think that some of those unforeseen circumstances can be dealt with between the parties. And we are of the view, with the provisions dealing with contracts and fair contracts and agreements and the guidelines by the legislation in the bill, we think that it will be sufficiently catered for. So we recommend that the recommendation not be amended.
Thank you very much. With that explanation, honorable members, those who agree, please raise your hands.
Chair, voting in agreement with the response, we've got Honorable Tango, Honorable Moimang, Honorable Mamrehana, Honorable Khai, Honorable Mashori.
Okay. Can you please lower your hand, honorable members? Thank you. Those who are voting against, please raise your hand. Against? Oh, okay.
Against, we've got Honorable Lunt and Honorable Bashokchi.
Okay, thank you. Can you please lower? Oh, there's also Honorable Pretaset. Those who are voting or those who are abstaining?
Chair, we have one, Honorable Matabula.
So clause 7 is therefore read to. In fact, the amendment, sorry, the no amendment is agreed to. Can we then vote for clause 7? Those who in favor of adopting clause 7, please raise your hand.
Okay, Chair, voting in favor of clause 7 as is Honorable Dango for Gauteng. We've got Honorable Mashuri for Free State, Honorable Khai for Eastern Cape, Honorable Mamrehana for Limpopo, Honorable Landsman for the Northwest, and Honorable Moimang for the Northern Cape.
Thank you so much. Can you please lower your hands, honorable members? Honorable Mashuri, okay. Those who are voting against, please raise your hand.
Chair, voting against, we've got Honorable Lunt and Honorable Bashar.
Honorable
Practices.
Okay. Thank you so much. Can you please lower your hand, honorable members? Those voting or those who are abstaining, please raise your hand. That's one abstention.
There's one abstention, Honorable Matabula, Chair.
Thank you so much. So clause 7 is therefore adopted, honorable members. Let's go to clause 8. Those in favor, please raise your hand for the adoption of clause 8.
Chair, for the adoption of Clause 8, we have Honorable Dango, Honorable Dango for the Gauteng, Honorable Mashuri for the Free State, Honorable Khai for the Eastern Cape, Honorable Mamarahana for Limpopo, Honorable Moimang for the Northern Cape.
And please lower your hands, honorable members. Honorable Dango, please lower your hand. Thank you so much. Those voting against, please raise your hand. Those are abstaining, voting for the adoption of Clause 8.
Chair, abstaining, we've got Honorable Ratsif, Honorable Boshoff, Honorable Lunt, and Honorable Matabula.
Thank you so much. Please lower your hands, honorable members. Therefore, Clause 8, honorable members, is adopted. Let's move to Clause 9, Advocate.
Thank you, Chairperson. The first proposed amendments on this is what we've already dealt with in respect of one of the previous clauses with Section 6A, dealing with equitable remuneration. So one of the specific proposal was in fact made then in respect of 8A as well. And the proposal is in fact that equitable remuneration be included in the heading in subsections 1, 2A, 3, 4B, and 5B. Chair, there are also other proposals on this clause. The biggest concern that I could see on this clause is that Clause 9, Section 8A, deals with performers. And there was a concern about the interaction between this clause in the Copyright Amendment Bill and the clauses in the Performance Protection Amendment Bill. And the response from the department was that they would recommend that Section 8A, in other words, this clause, is retained in the bill as the acts are in fact interlinked, and they can speak a bit further on that. The other aspects that I quickly want to just point out was there was a concern about contractual freedom being interfered with, but it is our recommendation that that is not the case. All that can be prescribed is the manner and form, in other words, where the witnesses are required, whether it must be in duplicate and so on. There was a concern about the inclusion of collecting societies, but that is necessary because if a collecting society is involved, the Act must then refer to them. There was also a concern about the tribunal and that it should not be included, but it is not recommended that the role of the tribunal be removed because they play a role in respect of the settlement of disputes between parties here. And then there was also a big concern regarding reporting, registration requirements and the sanctions linked to non-reporting and non-registration. And I'll also ask the department to rather speak to that. The last proposal in respect of amendment in respect of this clause from the Northwest in respect of the tribunal to set a royalty rate, and it is not recommended that that be deleted because it sets a dispute resolution mechanism there. It is a voluntary referral, and parties, if they do not want the outcome from the tribunal, they simply do not have to enter into an agreement. But the tribunal's role is where parties can really not agree on that royalty, that they can approach the tribunal to set something for them. Chair, so if I can just hand back to the department, to the DDG, in respect of specifically the reporting and the registration and the retention of 8A, but of course you can speak to the other matters as well. Thank you, Chair.
Thank you so much, Advocate. DDG.
Thank you, Chair. On the reporting requirements, I have alluded on it in various discussions in the committee when responding to the submissions. This is one of the requirements that stakeholders, including provinces, have raised concerns about to say that they are administrative burden. They have an administrative burden for the rights owners, because you then have a requirement to when you use a work, then there must be that reporting requirement. But then there's a policy context behind it, and that's why the National Assembly spent an extensive number of days on this in terms of the issues around there, to say there are currently many performers who are not receiving their royalties, but their works are being exploited financially, commercially over time. For example, there were examples used of broadcasts that are taking place in even SADC countries, where there will be you go to different areas where you find that an actor or actress's performance is seen on a regular basis. So there are series that are long-term from the past, but then they don't get their royalty. So there was that emphasis that there's a need to ensure that there's a recording and a reporting on the usage of performances, and that should be catered for in the legislation, and there should be stronger penalties for lack of adherence, therefore. So it's a policy context, and it was extensively considered, and it is a reality. We do see television productions, we do hear songs, and then you hear performers saying, I don't get anything for my work, I don't get paid for my performance as an actress, as an actor. And this was to answer to that problem, to say we need to ensure that there is responsibility, accountability. In the music industry, they talk about log sheets, that there should be a need to ensure that the sheets are kept and recorded. And so that's why this issue is very critical around that, to ensure that that is dealt with. On the interlinkages between the Section 8A especially, 9A also has a similar implication. This legislation, these two bills are linked, they're interlinked, inherently so. And by ensuring this linkage, one has indicated previously in the presentation that this is not unique to South Africa. I've seen legislation where both rights are catered for in the same legislation. And in this case, we have a copyright tribunal, we have collecting society model in the copyright amendment bill. For instance, the actors do not have a collecting society, and the copyright amendment bill allows for the accreditation and formation of these platforms. So we need this integration for more protection and availability of rights, and ensuring that there are other institutions that can support, for instance, the role of the commission as a regulator. So just to clarify that, thank you, Chair.
Thank you so much. Honourable members, with that explanation, those who vote in favor, please raise your hand.
Chair, those voting in favor of the we've got Honourable Dango, Honourable Mamrehana, Honourable Moimang, Honourable Khai, Honourable Mashodi, and Honourable Landsman.
Thank you very much. Can you please lower your hands, honourable members? Those who are voting against, please raise your hand.
Chair, against, we've got one member, Honourable Lund. And Honourable Browderseth.
Boshoff. Okay.
So against is Honourable Lund, Honourable Browderseth, and Honourable Boshoff.
Okay. Can you please lower your hand, honourable members? Those who are voting against, abstaining, please raise your hand.
Chair, we have one member, Honourable Matabula.
Honourable Chair.
Yes, ma'am.
Honourable. Yes, Honourable Mukaba, my apology for attending late because I was debating. I was trying to raise my hand to be in favor of the bill. So I'm having a problem with my gadget for raising hands. So I'm in favor of the bill for Limpopo.
Oh no, it's the permanent delegates who are voting.
Oh,
Yes.
okay. I just joined because I wasn't
Okay.
sure.
All
Okay,
right.
no,
No, it's permanent delegates. Yes. All right.
Okay.
Thanks.
Thank you.
Can we now, honorable members, adopt clause 9? Those in favor, please raise your hand.
Okay, thank you, Chairperson. Those members that have voted in favor of clause 9, and this is to accept can I just confirm that that is also to accept the amendments proposed by the CLSO and DTIC?
We've done that. Now we on the entire clause.
Yes, Chair, but to adopt the entire clause with the proposed amendments. I just wanted to confirm that yes. So
Yes.
in that regard, Chair, we've got for the Northern Cape, Honourable Moimang, the Eastern Cape, Honourable Hai, for Gauteng, Honourable Dango, for the Free State, Honourable Mashodi, for Limpopo, Honourable Mamrakane.
Thank you very much. Can you please lower your hands, honorable members? Those vote against the adoption of clause 9 in its entirety.
Chair, we've got Honourable Land, Honourable Prataseth, and Honourable Bashar.
Okay. Please lower your hand, honorable members. Those who are abstaining, please raise your hand.
Chair, we have one member, Honourable Matabula.
Thank you very much. That means clause 9 has been adopted in its entirety, including the amendments, the proposal that we've been made. Honorable members, at this stage, I think it's almost now 12:30. I think, as I indicated earlier, that we will stop at 12:30 so that members who should catch a bus to Parliament can do so. We will continue again next week on the 20th with this process. We're still on copyright amendment. So we're still going to deal as well with performance protection amendment bill. Honorable Prataseth.
Thank you, Honorable Khai. I just wanted to know, for tomorrow, we've received notice that the meeting is postponed. Does that mean we are not meeting at all, or that we're not dealing with the subject matter? Because I think there were other discussions that I think Honorable Dangle wanted to have about the tour. So can you just give us some guidance for tomorrow, either yourself, Honorable, or Honorable Moimang? Thank you for tomorrow. Thanks.
I was not aware. Sorry, I was not aware. I've not in my meet. Honorable Moimang, can you please clarify? I wasn't aware that the meeting is postponed.
Yes, thank you, Chair. The response that we're supposed to receive tomorrow from the Department of Transport in relation to the economic regulator of transport bill has indicated that they are not ready for tomorrow, and they made a request that we give them space and time. So as a result thereof, we acceded to their request.
Oh, okay. I don't know if Grace is here so that she can clarify the issue of the trip then, because I think Honorable Prataseth was also asking in relation to the update. I promised that it will be given tomorrow. At the time, I thought that the meeting was going to take place.
Good morning. Thank you, Chair. Good morning to everyone. The only thing I would like to confirm is that GERCO DIRCO is not able to accommodate us for the period, for the extension that we have requested as the committee. So therefore, our trip will start there in Germany on the 3rd. We'll travel from South Africa on the 1st and back to South Africa on the 10th of July.
Okay.
I'm busy with the DIRCO with regard to the note demand with Parliament. Then after that,
I don't know whether it's me. I think
after that, sorry, Chair?
I think we are losing you.
After that, I'll be able to communicate with TLS that does the Schengen visas as soon as I received all the information. But I will keep on communicating with members with regard to the arrangements through our group chat.
Okay. Thank you very much.
So that we can also decide as to when are we going to make an appointment to go to Greenpoint to do the Schengen visas.
Okay, we'll wait for the communication then on the WhatsApp group. Honorable members, can I check? Over to you, Honorable Protestant.
I'm really not trying to delay things, Chairperson, but can I just ask that we make every effort to make the Schengen visa appointments for next week? Because many of us, after the breaking up of the term, myself in particular, are involved in by-elections in that next week, which is the week running up to the 1st. So we can please try and expedite the Schengen visa appointments for next week and not the week thereafter, because that would be very problematic, particularly for myself. Thank you, Chairperson.
Thank you so much. Okay. Can we maybe target the Monday, because there are no committee meetings on Mondays. If you can try that, Mrs. Grace, so that maybe we arrive from our constituencies on Sunday, so that on Monday then we can go there.
It's noted, Chair, and then that will be communicated to you if I can make an appointment for Monday.
All right. Thanks so much. Honorable members, can I check now that we don't have a meeting tomorrow? Can I check if we can perhaps continue this process that we're dealing with of clause by clause tomorrow? Can I check your views on that?
I would be available, Chairperson. We need to conclude on this matter.
Okay.
Me too, Chair.
Okay.
Agreed, Chairperson. Agreed.
Okay.
Myself,
agree,
also,
Chair.
Chairperson, I'm going to be available.
All right. Honorable Lassman.
I have indicated I agree, Chair.
Oh, thank you so much. Honorable Protestant.
Chairperson, I'd already scheduled a dentist appointment, but it's fine. I'll be there.
All right. Thanks so much.
Honourable Chair.
Yes, Honorable Bishop.
Myself and Honourable Lont will also be available. What time? What time? 10 or 9?
Can we make it 9, please? Thank you so much, honorable members. Advocate DTIC, are you available tomorrow?
We will definitely be available, Chair.
Thank you so much. DDG Massage?
We are available, Chair.
Okay. Thank you so much. Thank you, Honorable Moima, for giving us the slot for tomorrow. So, honorable members, let me thank all the honorable members, permanent and special delegates for your attendance and participation. I'd like to thank Honorable DDG Masoja, Advocate Van Merwe, Advocate Samara Ali, the committee staff, the paramedic staff in general, our guests and the media, thank you very much for your attendance. The meeting is now adjourned.